Ballinas-Lucero v. Garland. I'll do 2 Ninth Circuit ones and then be done because you and I are both sweating desperately in the Ninth Circuit in Southern California during this heat wave. If I wasn't from South Florida, I don't know what I'd be doing. But to be honest with you, this is kind of child's play, actually. You don't know heat until you're dealing with power being out for 4 days following a hurricane in the middle of August.
Oh, it is humid over there too.
It is. Yeah. No, it's quite hot. It's quite hot, and we're getting through it.
The problem is every day. Like it's been 2 months where it's 100 every day. I grew up here. I never had this consistent amount of heat with no cool off. We were going to go to Disneyland yesterday. We canceled. I'm not going to Anaheim tomorrow and burn my head off over there. So
it scares me, right? I mean, it's global warming. It's climate change, and I don't know if there's any going back.
Yeah, it's kind of scarier than COVID because I'm like, oh, COVID, it's a disease. We'll get over it. But like if it's hot every day like this, like we can't live. Like I don't need to go out for work because we just do here. But there's people I gotta do work outside the house, and power line goes out. Someone has to go there, or laborers. Right. So like, how is people gonna do any work outside the house? So it's a messed up situation. Plus the water, but that's a side issue. Sorry, go ahead.
That's right. Let's make a deal. If either of us runs out of water, we'll help the other one out. You heard it here first on the podcast. I'll get quick with Ballinas-Lucero v. Garland. It's about vacated convictions. It's interesting because the guy, if we're taking him at what he testified to, he's like been this good guy, this father of 2 people here unlawfully, working at a manager at a Burger King for all these years, hard work. And he gives the wrong change, makes a mistaken change, which it can't be more than a couple dollars, to a mentally ill individual. And the mentally ill individual's caregiver accused him of trying to scam a mentally ill individual. And everything else in his life, at least based on this decision, showed that must have been a mistake. And who knows, just going based on what they said in this decision, what it seems on the testimony. But the guy accepts a plea by himself, not understanding English, in state court. And he's in deep because now that prevents him from getting relief. But on the appeal, he gets it vacated, and this is all about reopening his case. And the BIA denied reopening, but this case is very important because he gets it vacated under California Penal Code Section 1018. I'm not a criminal defense attorney. I know some people are, or they definitely use criminal defense attorneys. And what I'm about to say is a bit broad. There's a bit of context in this case, as they always are. But it seems that this is the Ninth Circuit saying that a vacated conviction under California Penal Code Section 1018 will satisfy the immigration standard in matter of Thomas and Thompson, matter of Pickering, and that conviction, that vacated conviction, is no longer a conviction for immigration purposes. And if that's what the Ninth Circuit is saying, and I think that is a reasonable interpretation of this case, Ballinas-Lucero v. Garland, that's huge, because it seems like Cal Penal Code 1018 is a common way to get convictions vacated. Again, that's not what I do. I farm it out. But that's a big holding. And, like I said on the podcast when I summarized this case a few weeks ago, criminal counsel needs to be careful in their memos to the state court because those are going to get admitted into immigration court. And if criminal counsel saying we need to get this vacated for immigration purposes, maybe immigration judge is going to look at that and say, I don't care what the Ninth Circuit said. I'm reading that decision narrowly. It's clear here that it was for immigration purposes. So I'm not going to recognize this vacated the fact that it was vacated. I think that's possible. And then you're litigating that issue before the BIA. Mm-hmm. So make sure that, but also it seems that you can't, that's the whole basis for the Ninth Circuit saying that a Cal Penal Code Section 1018 vacation will work. The whole basis is that statute in California is substantive. It shows that there was something wrong with the underlying conviction. And quite frankly, then, if that's what they're saying as a matter of law, it doesn't matter what you write in your legal brief. Yeah. That's just bad attorneying. But as a matter of law, all you needed to prove was there was a substantive error. Cal Penal Code 1018, check it out. Tell your criminal counsel, as I said on LinkedIn and on the podcast.
Get the word out with this.
And send your colleagues matter of Thomas and Thompson and matter of Pickering, because they need to know that when they're getting a conviction vacated. Because if they don't, what they're doing is just a waste of client money. Because Attorney General Barr really limited the circumstances whereby immigration judges are permitted to recognize the effect of a vacated conviction.